In the New Lottery Company Limited and Northern and Shell plc versus the Gambling Commission, Mrs. Justice Joanna Smith determined at a consequentials hearing whether the defendant and interested parties were entitled to indemnity costs across the entirety of proceedings arising from the fourth national lottery competition. It was common ground that the claimants were liable for costs. The dispute concerned the basis of assessment. The claimants conceded that indemnity costs were appropriate for at least the trial of the process claim, but argued that standard costs should apply to the modifications claim and to earlier stages. Applying the principles in Excelsior Commercial and Industrial Holdings Limited versus Salisbury Hammer, Aspden and Johnson, Three Rivers DC versus Bank of England, and Hislop versus Purdy Corps, the court held that conduct warranting indemnity costs must be highly unreasonable and out of the norm. The court found that the claimants had advanced inadequate and unparticularised pleadings from the outset, made serious allegations of impropriety that were repeatedly abandoned without explanation, and pursued weak and speculative claims in a fluid and opportunistic manner, causing significant prejudice and disruption. The court rejected the submission that proportionality of the winning party's costs was relevant to whether indemnity costs should be ordered, and declined to divide the order by issue or time period. Indemnity costs were awarded to both the defendant and the interested parties across the entirety of both claims. Quote, "Accordingly, the conduct that I have found to be highly unreasonable is, in my judgment, conduct running through the whole of the case. It plainly warrants a costs order for indemnity costs in relation to the entirety of the proceedings. Further, I agree with Mr. Howard that there is a need to mark the court's disapproval of such extraordinary conduct by making such an order."
For a detailed summary of this decision, visit tmclegal.co.uk.